Now, given this information about the privacy and the related things, let's take a look at the case Insight on Technology, Apple Champions of Privacy. It discusses the implication of automated smartphone assistants like Siri and describes how Apple and other big smartphone players are approaching potential privacy issues. Discussion questions might include the following. What resolutions does Apple propose in keeping customers' data private? How do approaches to privacy differ at Apple, Google, Microsoft, and Facebook? How are they similar? Why have potential digital assistants become such a hotly contested battleground? Would you give up privacy for a better personal digital assistant? Now, let's briefly walk through the general privacy legislation. Tables 8.6 and 8.7 illustrate evolution of the Federal Trade Commission's approach to privacy issues. Table 8.6 covers the FTC's initial fair information practices doctrine. Table 8.7 lists the FTC's initial recommendations on online profiling. Table 8.8 highlights the FTC's most current thinking on these issues. It is important that you understand that at this point, these are just recommendations, as they have not yet been enacted into law by Congress. You should visit ftc.gov as well as privacy advocate sites such as epic.org and cdt.org. You would find it interesting that Europeans in the European Union have a much stronger set of privacy laws than the United States. Let's discuss legal protections. In the United States, Canada, and Germany, rights to privacy are explicitly granted in or can be derived from founding documents such as constitutions as well as in specific statutes. In the United States, the claim to privacy against government intrusion is protected primarily by the First Amendment guarantees of freedom of speech and association, the Fourth Amendment protection against unreasonable search and seizure of one's personal documents at home, and the 14th Amendment's guarantee of due process. It is important to remember that these protections apply to government intrusions of privacy, not private firms' intrusions. In addition to common law and the Constitution, there are both federal laws and state laws that protect individuals against government intrusion and in some cases define privacy rights vis-a-vis private organizations, such as financial, educational, and media institutions. Now, informed consent and notice. One conceptual basis of American privacy law is notification and consent. It is assumed that consumers can read terms of use notices concerning how a website will use their personal information and then make a rational choice to either consent to the terms of use, opt out of the data collection, or stop using the site. The concept of informed consent also plays an important role in protecting privacy. In the United States, business firms can gather transaction information generated in the marketplace and then use that information for other purposes without obtaining the explicit affirmative informed consent of the individual. For instance, in the United States, if a shopper purchases books about baseball from an e-commerce company that participates in an advertising network such as DoubleClick, a cookie can be placed on the consumer's hard drive and used by other member companies to sell the shopper sports clothing without the explicit permission or even knowledge of the user. This online preference information may also be linked to the personally identifying information. In Europe, this would be illegal. A business in Europe cannot use marketplace transaction information for any purpose other than supporting the current transaction, unless it obtains the individual's consent in writing or by filling out an on-screen form. There are traditionally two models of informed consent, opt-in and opt-out. The opt-in model requires an affirmative action by the consumer to allow collection and use of information. In the opt-out model, the default is to collect information unless the consumer takes an affirmative action to prevent the collection of data by checking a box or filling out a form. Now, let's change the topic to intellectual property rights. This section defines intellectual property and describes the three main ways society has chosen to protect intellectual property: copyright, patent, and trademark. In terms of copyright, the main distinction to get across is the difference between an idea and its expression. Copyright protects the expression, not the idea. ideas and expression converge so that some ideas can only have one expression. Take Microsoft's Windows and Apple's version of Windows, for instance. The most important recent development in copyright is the Digital Millennium Copyright Act, DCMA. Two significant provisions in this act are the provision against breaking encryption codes that protect intellectual property and the safe harbor provided to ISPs and search engines that take down infringing content. Google has invoked the safe harbor provision in the lawsuit by Viacom with respect to YouTube videos. Patents. Patents protect ideas for a limited period of time. The danger of patents is that they may stifle competition. Figure 8.14 looks at the ongoing patent battle being waged by Apple and Samsung over their smartphone features, and Table 8.15 provides a list of selected e-commerce patents. Trademarks. Trademarks help identify and distinguish goods in the marketplace. They play an important role in branding. E-commerce has created opportunities for mischievous behavior by violators of trademark. Table 8.16 provides a list of various internet-related trademark issues and related legal cases. Now an interesting topic of taxation. During the early years of e-commerce, it was customary to think about the internet as far too powerful for any government to control. We know that the internet, or at least the key players such as ISPs, e-commerce sites, and telecommunication carriers, can be controlled just as in other forms of media. One of the more interesting government issues in the United States is the taxation of online purchases. States and localities are pushing hard for a slice of the e-commerce business pie. The Insight of Business case, Internet Sales Tax Battle, takes a close look at this issue. Questions for discussion might include the following. Given the nature of the internet, should sales tax be based on the location of the consumer rather than the seller? What are the different approaches Amazon has taken with respect to sales taxes? Are bricks and clicks retailers disadvantaged by local sales tax laws? Another topic for discussion is net neutrality. Net neutrality is another issue that has been in the news in 2015, with the FCC ruling that internet broadband service providers should be viewed as public utilities similar to telephone companies, and therefore regulated by the FCC in order to ensure fair access to all deployment of acceptable broadband service levels and competition among providers. However, the debate over net neutrality is not conclusively over, with the large telecommunication carriers preparing legal challenges. The last topic is public safety and welfare. How could e-commerce affect public safety and welfare? This section will at first puzzle many of you. Let's take a look at the Insight on Society case, the drug, and address the questions in the following. What's wrong with buying prescription drugs online, especially if the prices are lower? What are the risks and benefits of online pharmacies? Should online pharmacies require a physician's prescription? How do online pharmacies challenge the traditional business model of pharmacies and drug firms? What are the challenges in regulating online pharmacies? Who benefits and who loses from online pharmacies? Thank you.